to the best possible. Oh, recording in progress. So it's about which systems you should use considering the data that you hold. So whilst we're not going to say there's this perfect system out there that's best for everybody, the point is using the system that's fit for purpose for you. So how easy is it for you to access your data, to understand what data you hold, where it is? If you're being asked for data from a third party, where is it that the information is going to be recorded, and how easily accessible is it, not just to you potentially as senior staff members, but also for all of your staff. And again, as you'll see, this goes as relevant to kind of local level inquiries as it does to, a CQC enforcement notice. So our staff being asked in an inspection, where is this particular piece of data, making sure that you have the training and knowledge to understand where that data is, and that all of your staff do. And really just about making sure that you're making the best use of your systems, because ultimately you could have the best system that's fit for purpose, but if you haven't had people trained on it, if you aren't consistently doing refreshers on how to use that data and in what circumstances, then you're not getting the best out of your system. As Fiona said, please do ask any questions. Fiona will interrupt if there's anything in the chat that she thinks would be useful for us to answer. Sometimes we're going to say, actually, the answer to that is in a few slides' time, but sometimes we'll be able to answer that question then and there, and potentially with examples. So moving on to the piece that I'm doing, this is more about how you would use data at a local level, and sometimes how important it is without potentially considering what it is you have available to you and how it can be used. So in relation to disclosure to third parties and commissioners at a local level, you are going to be sharing data on a daily basis, on a weekly basis, on a monthly basis, without necessarily considering the implications. And a lot of the time, that's perfectly reasonable. You're going to be updating families in person or on the telephone. You're going to be having discussions with community nurses and other healthcare professionals. You're going to be picking up the phone, you're going to be sharing an update and not necessarily considering about where that data goes. However, in terms of those more informal communications, and one of the things that we really want to stress during this webinar is that it's important to remember that you are sharing data and that that information is going somewhere, whether or not it's being recorded. Oftentimes, especially when we're talking about the sector that we're in, we are talking about a person's personal data. And so it's about consent. Do you have the consent to share X information with the family? Has there been a consideration in relation to sharing certain types of information with certain family members and not with other family members? Are you considering the best interest considerations? These aren't within themselves principles that we're going to go into any great detail in the seminar, frankly, because we don't have time, but also because we would hope that that's something that already underpins your practice. But again, it's just a refresher to make sure that when you're picking up that phone, when you're sending that email, you need to consider the circumstances of that. In terms of the context within which the information is requested, I would always say, effectively take a deep breath before you share something. If a social worker or a caseworker calls you or emails you and asks about a particular instance, there's been a complaint from a family member, for example, you instinctively know all of the context of that, and your first instinct is to send back a quick email with a summary in relation to the explanation of events. You would assume that the caseworker is going to pick up the telephone if they have any further questions. However, the reason that we're talking about this is because specifically some of those more innocuous questions or complaints can be escalated as a potential safeguarding. Now, why is that important? Well, it's important because Section 42 safeguarding inquiries exist under the Care Act. As I'm sure you'll know, it's the duty of the local authority to make any inquiries or to have others do so if they consider that there's an adult that might be at risk of abuse or neglect. Now, these Section 42 safeguarding inquiries can range from having a quick conversation with the person who is potentially considered to be at risk, or it could be escalated all the way up to a multidisciplinary team meeting. And again, as you'll we'll discuss further in due course, it can also lead to it being escalated even further into a wider and more significant investigation. Now, local authorities do have an absolute duty to investigate all safeguarding concerns. When we as lawyers talk about an absolute duty, we mean it's a duty that they can't get away from. If they are informed of a safeguarding concern, they have to consider whether or not it needs investigation, whether or not it meets the threshold, and then whether or not it reaches the threshold of a Section 42 safeguarding inquiry. And actually, that threshold is quite low level. And so what they need to do is consider whether or not it's a safeguarding concern, or if it's not, but if they consider it to be a safeguarding concern, then that triggers that Section 42 inquiry. So why is the power of data, which is what we're talking about today, why is that important in terms of a Section 42? Well, we first need to consider the threshold, as I said, and we put a quote here because we're lawyers, we put a case quote, but effectively it's about a sensible risk appraisal. So it's not striving to avoid all risk, whatever the price, but seeking a proper balance and being willing to tolerate manageable and acceptable risks. Well, why is that relevant to data itself? It's relevant because you have the opportunity to put forward to the person who is conducting the inquiry all of the available information, so they have that opportunity to consider and to balance those risks. So simply saying, oh, I know what happened, Joan fell, people were around, don't worry about it. Well, yes, that's absolutely correct, but you may have a caseworker who's time short, as you all are, resource short, and considers that to be your feedback. So is there anything else that you can be doing with data when you get that email or when you get that telephone call? And the first thing that I would say, just as a slight aside, is if it is a telephone call, please do the annoyingly boring lawyer thing and write an email to the person you were speaking to afterwards and say, hi, thanks for this conversation. I understand that this was the discussion that we had. The reason for that is if you're not taking a note, you can't guarantee that the person on the other end is taking a note. There may be things that were misinterpreted in that conversation in circumstances where you may later have to rely on that, where someone annoying like me or Maddie or Isabel comes to you and says, yes, but what did you do at 10 o'clock in the morning on a Tuesday 6 months ago? You're going to look at us like we're crazy. We're going to be asking you for evidence. So if you do have that evidence, say, well, actually, just afterwards, I sent that quick email to the social worker saying, thanks so much for the conversation about Joan. This is what we put in. Please do let me know if you require any further information. So in terms of that initial email, as I said, the issue that we wanted to flag specifically in relation to Section 42 inquiries is that actually that might be not only the first, but the only opportunity that you get to feed into that. And the reason for that is the way that the Section 42 inquiries are formulated. So they're formulated to make sure that it's done with and not to the person, but the person is the focus. So the caseworker or the person that's running that inquiry needs to be doing that with all of the information from all of the different strands. But there's no specific guidance, or at least there is specific guidance, but it's not necessarily followed in terms of the type of weight that a caseworker should be applying to those different pieces of evidence. So our advice would always be, when you get that opportunity to feed into an investigation or a safeguarding complaint or a concern, not just those couple of sentences and hoping that they get back to you, saying, actually, I have this information in terms of the records. I have the information into the root cause analysis investigation we did. I have the professional visitors meetings, whatever they may be. Because specifically, in relation to a Section 42 inquiry, the obligation is to safeguard the person. It isn't to assist the service to make sure that their voice is heard. Now, this is despite the fact that Section 42 conclusions, outcomes, will stay on the record for the local authority, and they will be considered by commissioners. they will be considered by CQC during inspections. And again, Isabel is going to go into some further detail about the type of information that CQC look for. But something that you consider to be an innocuous back and forth couple of emails may have become a Section 42 inquiry without you necessarily knowing about it. In fact, during the course of that inquiry, as far as we often have that experience from our clients, they aren't updated in relation to the status of the investigation because ultimately they're not the focus of the investigation, the person is. They may not even be informed if there's a conclusion. In fact, I've had 2 relatively recent situations where we found out that there was a Section 42 outcome as a result of another safeguarding being raised. Not because it was something where the local authority had written to our client to say, we now have a safeguarding outcome, we have a Section 42 outcome. So it's important that if you believe that there's an investigation ongoing, using the data available to you. So as I said, it may well be that the outcome isn't shared with you, but it will be recorded. It will be recorded by the local authority. It will be kept on their records for the persons involved. Many local authorities do not provide a formal route to challenge the findings of a Section 42. So if you don't feel that your voice has been heard during the inquiry as a provider, as staff team, you don't necessarily have the opportunity to feed back into it. Now, there is best practice guidance. There's best practice guidance that's been provided by the Local Government Association and then later by the Local Government Association in line with ADAS as well. They are only best practice guidance, though they're not binding. So we would always say in circumstances where you consider that there's further information that you could provide after that first email, please do so at the earliest opportunity to say, we're aware that you're investigating, you may find this additional data useful. So the emphasis of the Section 42 guidance is that it's about the shared responsibility for safeguarding inquiries. It's supposed to be collaborative decision-making. It's supposed to involve joint accountability. The reason I'm emphasising supposed to is because of what I was saying. It's best practice guidance that's not necessarily being rolled out by local authorities. So don't assume that they are actively working with the service. And this isn't necessarily part of malicious intent on behalf of the local authority in any way whatsoever. But it's about the fact that, as I said, they're time poor, they're trying to gather information from often multiple different sources, and they may not go back to you to say, do you have additional information in relation to this point? So you said that this person had the unwitnessed fall. Well, were they on a one-to-one? Should they have been on a one-to-one? Were there any additional risk assessments? All of that type of information, as I said at the very beginning, when you get that first request through for information, take a breath and consider what information, what data you have available to you that you can share in the first instance, using your symptoms, harvesting the relevant data and sharing that with them. If you consider there's additional data that you may want to provide in due course, I would also put that in the response to say, you know, at the moment, we are undergoing an investigation in relation to this unwitnessed fall, or we are doing a root cause analysis. We will provide this to you in due course. So don't wait for the local authority to come back around and ask for that information. If you have it, if it's been checked through all of your systems and processes and audits, please do consider sharing it. Ultimately, what it's about is putting your best foot forward as early as possible, using the data, using your systems, as I said, making sure that those systems are fit for purpose to begin with, so that you and your staff feel confident that when you are sharing your data, when you're putting your position forward, you have put the best information that you possibly can do. This obviously relates to the fact that your systems themselves need to allow easy data gathering, and that your training says, you know, if we receive a request in relation to a safeguarding or a complaint, this is the type of information that we provide. These are the regional heads or the area managers that we would go to just to check first. the number of times where, especially with CQC or with Inquests, for example, we find out that a very, very well-meaning registered manager, for example, has sent a ton of documentation through, but actually without checking with somebody else first to support them to make sure that they've gathered all of the information that's available on their system. We don't want to be trying to go back 3 months later to explain why we didn't include X care notes because we only provided the daily notes, if actually the professional visitors notes, for example, could have really assisted. So just making sure, taking that breath, hoping that there's going to be somebody else there that can kind of double check what you're doing. And as I said, just making sure that your position, the services position, is recorded and it's considered at the earliest opportunity. So now I'm going to pass over to Isabel, who's going to talk to you about CQC.
Good afternoon, everybody. I'd like to talk to you about CQC and the role of data in practice. So what I'd like you to do is think about the data that you have and the data that you've already provided to CQC with a lens on it as if you were CQC, and consider what image they might have of your service based on the data that you've already provided them with. So, for example, CQC already holds information from the provider information return that you provided to them, and also the PIRs that you provided to them over the years, the notifications that you or others have provided to them, your previous inspections, including their own notes, as well as the draft and then the finalised report and any submissions you made during that process, any safeguardings that they've been made aware of, any whistleblowing. And then also there's the feature, tell us about your care. You may or may not have been informed about information that's been provided to CQC by way of data using tell us about your care. Currently, CQC are trialling a new feature, which is a chat, and it's currently unknown whether information from that will be made available to providers. And then there's obviously the data that you provide, the data that you provided to CQC during an inspection or an assessment, and the notifications that you provide to them regularly. So CQC is currently operating using a risk-based approach. So it will have considered this data and other information in the round to consider whether you are a higher priority or not for an inspection. And it's important to note from what Nicole has just informed you in relation to safeguarding that CQC will be made aware by the local authority of safeguard information that they have about your service, which you may or may not be aware of. It's important when thinking about your records also to think about whether you hold information in one place or whether you hold information in multiple places, and does that information triangulate, or is it better, rather than considering whether you duplicate information in more than one place, to consider whether you simply signpost from one piece of data to another. That can be really useful to have done that from a strategic point of view before you have any kind of CQC inspection or assessment. So considering also what information is available to CQC and others without you being aware that somebody is searching for that information. So the DSPT, which hopefully you all know and are aware of, and are all standards met or standards exceeded. But if you're not, the Data Security and Protection Toolkit is an online self-assessment tool that allows organisations to measure their performance against the National Data Guardian's 10 data security standards. All organisations that have access to NHS patient data and systems must use this toolkit to provide assurance that they are practicing good data security and that personal information is handled correctly. Now, it's very important that you are aware of where your organisation sits in relation to this, because this web page that you can see a screenshot of, it is an open web page. You can do an organisational search either by using the name of the provider or something called their ODS code. And this is available to members of the public. Obviously, it's also available to CQC. So completion of the DSPT is also necessary for organisations which use national systems such as NHS email and also the e-referral service. And that's a large proportion of providers now. So if you are not currently or have not currently completed this process, it's really important that you do so. Thank you, Eleanor, for the link to DSPT from the Digital Care Hub. So when a search is done on the DSPT's website, you can see what version of the standards the organization has met. You can see, for example, at the top there, approaching standards, which means that they're on their way. And the date on the right-hand side is their last publication date. You can see all the way down there. You've also got standards exceeded, or standards are exceeded where the organization has a current Cyber Essentials Plus certification as well. Where an entry says not published, it means that that provider has not completed the DSPT. As I said, this is a freely available search. Indeed, organizations do use this, and it's available therefore to CQC, so they can look without even leaving the office where you are in relation to your data security protection standards. And I'd just like to emphasize that in CQC's well-led key question, under the governance management and sustainability quality statement, they have as an evidence category, data or notifications are consistently submitted to external organizations, as well as a subtopic, cybersecurity and data security protection toolkit. It doesn't have to be the DSPT, but if it's not, it must be an equivalent. So thinking about another system that you provide data to, the capacity tracker. So currently, the North of England Care Support System, in partnership with NHSE and others, developed the capacity tracker. It's something that providers became very familiar with, particularly during the COVID time, but it was mandated in April 2025 that the Secretary of State required providers registered with the CQC under Section 272A of the Health and Social Care Act to provide certain information. Examples of the information that you provide is on the right-hand side of the slide. So, for example, you provide workforce resourcing, including absences, care home bed vacancies, and also your maximum capacity. All of the entities on the left-hand side of the screen are all of the entities that receive this data from you, whether you realized it or not, when you do this on a monthly basis. And of course, that gives them really useful information, not only monthly, but also they have access to that data over time. And an example of where this can lead to, sadly, a negative example follows. Thanks, Maddie. So a Section 33 letter was issued to a provider who had completed the capacity tracker. And this letter outlined the offence, and the offence was as follows. The offence is an offence of failing without reasonable excuse to comply with a condition of registration. Namely, the registered provider must only accommodate a maximum of X service users at this specific location, specified in Section 33 of the Health and Social Care Act 2008, which occurred while services were being provided in the carrying on of a regulated activity or as a consequence of the carrying on of a regulated activity. This offence can be dealt with by way of a fixed penalty notice, a £4,000 fine, or prosecution, which carries an unlimited fine. Later on in the same letter, CQC outlined where it had obtained the information from. The Care Quality Commission received information in the form of the Capacity Tracker report as part of the inspection dated August 2025. The provider had completed submissions to the NHS Capacity Tracker for the period of January 2025 to July 2025. This evidenced a total resident count of between X and X plus 5 service users. This evidences the failure to comply with the condition of your registration. So whilst the provider was doing exactly as it should by providing the correct information, the accurate data on a monthly basis in accordance with the direction, its statutory obligations, unfortunately what it also did was that it hadn't considered that actually it was acting outside of the scope of its registration. So another concept that we are very aware is a hot topic amongst providers at the moment is the use of AI. So I'm not here to suggest whether AI is a good or otherwise idea. I'm also not here to suggest how or which systems should be used. What I'm asking is that you consider some of the following when you are considering AI, and that you do so again thinking about it from a CQC perspective and their lens. So an AI tool used in a service drew an adverse inference from an incident or accident. So the AI tool had looked at their records and had come to a conclusion. CQC noted that when they looked at this information, that it was not clear that the inference related to the past, and that the preamble to the conclusion could have been clearer. Now, because nobody in that provider had reviewed what had been created by the AI or amended the preamble, and therefore it was part of the record, CQC considered that it was not sufficiently clear. The provider's position was that it was sufficiently clear. There is an issue there, and you know the regulator gets to decide what its position is on the information that they were presented with. So remember, in the context of AI, that AI should be your servant and not your master. So just because that is what AI that you've chosen to use has come up with does not mean it is accurate, does not mean that it is complete, and may be factually incorrect. You should consider whether you have a definition in your service of what AI actually means in the context of your service. And do you have a policy on the use of AI and also of generative AI? These are things that are being widely used in the population now. There's no reason to think that somebody in your service may not already be using this. So if you don't have a policy in relation to AI or generative AI or both, it would be a very good idea to consider what that policy looks like. An example would be that artificial intelligence may be defined as a technique that uses machines to replicate the capabilities of the human mind. So your policy should actually define what AI means in the context of your service. Consider who created a record, if there is a version history, if it was produced with AI, is that obvious, and has it been reviewed and updated? Has the use of AI been risk assessed in your service? And can AI be used to assist and augment your care? If you don't know that your team are using AI, how can you have governance of the same? It's really important that you have those conversations with your teams openly. And there should be a names person in your organization who is the person that signs off use of AI. And there are really interesting studies being done in terms of predictive analytics, enhanced documentation, and quality assurance. If these are things that you want to do to innovate, please innovate with your eyes open and make accurate records of the decision making and complete risk assessments, and obtain consent and think about how secure that information is going to be. So sadly, negatively, AI was used in a service. This is an extract from a home care provider. They scored a 1 for the governance, management, and sustainability quality statement under well led, which I mentioned earlier. And I just want to read you 2 sections from CQC's published report. It says the provider did not have clear responsibilities, roles, systems of accountability, and good governance. Where audits or investigations were carried out by the acting manager, prompted by an inspection, artificial intelligence had been used to generate auditing templates and reports. This practice raised concerns about reliability and data privacy, as the use of confidential care records with AI had not been risk assessed. This lack of robust governance and failure to implement sustainable systems did not ensure people received high quality care and increase the risk of harm. Thanks, Manny. So also, I'd like you to consider, please, providing data from in the context of an inspection or an assessment, but through the lens of CQC. So CQC has inspected your service or is conducting an assessment. Your assessment window is open, and they have asked you to provide them with information. They have perhaps provided you with a very long list of the information that they would like you to provide. Think about where this information is held. Think about how securely this information is held, how are you going to give this information? How are you going to provide this information to CQC? I'd just like to talk you through an example of a situation that happened with one of our clients where they had concerns about the method that they were being asked to transfer this data to CQC. They were asked to transfer this data via a public Dropbox, and they were concerned about the safety and security around that. They said that they did not consider it sufficiently secure to transfer the data in this way. And so our client waited for a secure link, which was provided by CQC. And then that secure link was used to provide CQC with information that CQC had required. Sadly, in the case of this particular client, in subsequent tribunal proceedings, they followed action by CQC to cancel their registration. The lead inspector's witness statement claimed that our client was being obstructive by requesting a secure link. This was not the case. Our client was just trying to ensure that the information that was transferred was done so in a secure way. If you are not comfortable with what you're being asked to do because you don't think it's secure, it's very important that you record that you've had that conversation, perhaps email the inspector, email the manager if it's part of a complaints process, and explain that you would like to provide this information, that you are not being obstructive, you understand how important it is for the regulator to have access to this information, but that you have concerns and that you would like the data to only be transferred in a secure way. A little bit like Nicole said earlier in relation to safeguarding, record, because then you have that for evidence later on should it be required. So on a positive note, data can also be used to evidence outstanding. This is an extract from a provider's published report where they achieved outstanding. To examples, evidence the use of data to evidence to the inspection, to the inspectors as part of the inspection of some of the way that they do things in a unique and innovative way. So, for example, some people and their relatives told us about falls they had experienced when not being supervised with mobilizing or toileting. Now, on initial reading of that, that's the sort of thing that might cause somebody to take a sharp intake of breath. Because you might expect actually what's going to follow is, oh dear, they were letting people fall over. But actually, it says we discussed these with the management team who showed they had analysed incidents where people had potentially been left unsupported. These incident analysis records had led to improved measures being implemented. The management team ensured they actively listened to feedback or concerns from people and their relatives to improve care quality. So this service was able to take a situation that could otherwise have been a negative situation and turn it into a positive situation because they had used the power of the data that they held to make change. They had recorded the same. They had done incident analysis and they had recorded the measures that they took, and then they had recorded the outcome of the measures that they had taken. And I know that's a lot of recording, but it turned the page for them, and it is really, really positive, obviously, for the people concerned. Equally, if daily records of people who were being encouraged to increase their fluid intake showed this had not been achieved, there were flags in place on the electronic system to alert staff to this. So, for example, the use of an electronic system for things like flags or banners for allergies, things like that can be really, really useful and really important. Visual aids, prompts for your staff. They're not taking your staff's role away from them, but they are enhancing their ability to remember and to review and look back. It's a bit like administering PRN medication and then making a record to see whether the PRN medication had the outcome that had been intended. And thinking about CQC also in terms of system access. So when we're talking about systems, we're not just talking about electronic systems, we're also talking about the way you approach running your service and your paper records as well. There are situations where you may require agency staff or other staff may come into the premises and need to make a record, or indeed the general practitioner, TVN, CQC themselves potentially. So how are they going to do that? How are you going to give somebody else access to your system? I would like to suggest that this is not a consideration you make at the time, but you think in advance how you're going to make this happen, so that if at any point you need to give somebody access, how will that be done? It would be suggested that it would be a particularly poor idea to give somebody else's login and password in order to give them access, and that you should also consider the permissions that you're going to give each type of person who might access these systems, so that the record, any record that they make, clearly records their name and also the date and time that any amends that they made. That is very important, especially we've seen situations where people have given agency staff an agency login, and so all you ever see against a record is the word agency, not a name. That is not a clear and accurate contemporaneous record of all care given. It's also very important that you consider, if you're not going to give agency staff, for example, access to your electronic recording system, how you ensure that anything that they record on paper then becomes part of the accurate record. And this quote is from a letter of intent under section 31 to a provider. And it says agency staff did not have access to the provider's electronic recording system and were completing their records on paper. Their process lacked any clear or robust system to ensure that information was then being added in a timely manner to the electronic recording system. This meant the provider would not have an accurate view of the service users' needs and risks. As staff said, they did not have time to upload every paper record onto the electronic system. So that clearly evidences a paper system, an electronic system, and then a way of working system. And those three things not working terribly well together. So it's really important you give yourself the time to take a step back and consider how you are going to enable access to others to your systems. Thank you so much. Handing over to Maddie.
Hello. So I am now going to be talking about inquests in the coroner's court and the role of data and what it can play and what an inquest might look like. So it's not the purpose of this webinar. We could be here for hours, but I'm going to do a bit of a recap of what an inquest actually is. So I can say if we could do a poll, I'm not going to do it at the moment, but it'd be good to know in the chat, maybe if people have been to inquests before, if you've ever had to do witness statements, any disclosure for a coroner, that would be really helpful to know actually how much do you guys know about inquests. So first things first, it's not a criminal trial. Don't picture the Old Bailey, that's not where you're going to be. Most coroners' courts are in local authority offices. It's a fact-finding investigation. It's led by a judge, so the coroner, and the coroner has to answer 4 main questions about someone that's died unexpectedly. They've got to answer who's died, when did they die, where did they die, and how did they come by their death. And normally the first 3 questions are quite easy. Again, following on from Nicole's example, we know Joan died, we know she died yesterday, and we know she died in our care home. And we might think, well, she fell, hit her head, and died. Answer solved. But actually, how did she come to a point of falling in the way that she did? Was she alone? Was she meant to be supervised? Was it meant to be risk assessed? Those are all the things the coroner's thinking about. It goes a bit broader than just what's the medical cause of this person's death. An inquest doesn't apportion blame. It's not criminal, it's not civil. You can't go to prison, no one can get sued, no one can make any money out of an inquest. And because it's inquisitorial, it's fact-finding. We don't have parties in an inquest. Everyone's called an interested person. So that's being interested in the proceedings and basically knowing what conclusion the coroner comes to. We deal with lots of care providers that are IPs. So they could be a care home or a residential nursing home or a children's home even. We've also helped directors, so people a bit higher up from the care home as well. And once you've got IP status, you have the right to receive evidence. It's called disclosure in this court hearing, but the disclosure is basically our data. And you get some other rights as well. You get to question witnesses, you get to make submissions to the coroner. And again, it would make this webinar very long, but I've just very briefly said there are some extra complications that an inquest can carry. So a coroner can make a finding of neglect at the end of their conclusions. And again, doesn't carry much consequence in the context of an inquest, but obviously neglect is a criminal offence as well. It might have civil implications if the family choose to sue and you've breached your duty to provide a duty of care. And the coroner can also make a decision to engage Article 2 of the Human Rights Act. So again, that's a huge topic. Article 2 is your right to life. Normally that's engaged maybe if somebody dies in prison or under the Mental Health Act if they're detained at the time. So they can very much be relevant to a healthcare inquest. And I say no one can win or lose an inquest, but you can definitely come out of an inquest worse off than others if a coroner chooses to make a prevention of future deaths report. So it's essentially where a coroner gets to the end of an inquest and goes, okay, fine, we know what happened to this poor person, but I'm not reassured that this isn't going to happen again. And the coroner makes this report, it's public, it goes online, it comes quite high up in the Google searches, so commercially it's not great at all. And it's the coroner setting out their concerns, and you have to publicly respond to them and say what we're going to do as an organisation. Maybe it's a hospital or a local authority or a care home or a school, you know, whoever the coroner is targeting this at, you have to respond. So that's an absolute whistle stop tour, but that's essentially what an inquest is and what we're trying to avoid if we're involved. So what are we actually talking about when we say data in an inquest context? So quite often, we work with lots of care homes in inquests, and the first point of call is the coroner will go, we know this person died in your care home. We want all the relevant records about Joan. And what does that mean? What if Joan's been with you guys for 15 years? Where do you even start? Sometimes coroners can be really helpful and go, we know she fell a week ago, but we know she started having falls about a month beforehand. Send us everything for the last month. That's really helpful. Sometimes coroners won't do that, and you're left with a situation if we've got 15 years worth of records, what on earth do we send? You don't want to send everything. So, and as solicitors, that's what we can help you with, sifting through and working out what do you actually need to send, what's useful to a coroner. You'll always hear us saying you need to assist them, you need to be useful. And I'll come on to it later, but coroners basically don't have a lot of time to sift through 15 years worth of records. Some data might be really obvious, you know, Joan's care plan, her risk assessment, incidents, any falls, the daily care records, but the day maybe she had her fatal fall, was she particularly was she not in a good mood? Had she seemed really agitated? The incident reports, what did staff do? Were observations taken? Was an ambulance called? Staffing records, who was on shift? If a coroner wants to call witnesses, do we actually know who they could be calling? Was there an internal investigation done? And then I've gone a little bit further thinking about emails. Did we talk to other people about the fall? And did another party or maybe someone internal say, don't worry about it, she falls all the time, no further action taken? If we're going to rely on that and say someone else said that, do we need to now disclose an email as a bit of our disclosure and a bit of our data? And similarly with training matrices and any supervisions, let's say that Joan was being supervised by someone that hadn't had any training in relation to falls. The coroner is going to be quite interested to know that, and we'd have to address that. What are we going to do to make sure that doesn't happen in the future? So this is kind of a bit of a legal tangent, but it's good to know that this exists if you are ever involved in an inquest. So there is a case that established the Worcestershire Principles, and essentially it establishes the principles for when a coroner discloses things to the other IPs, so the other parties. In the first instance, I've got here, it's a two-stage test. You send all your data, all your disclosure to the coroner. The coroner is going to review everything, and then the coroner decides if they're going to send it to the other parties. Quite often the coroner does, but sometimes there are situations where we want to tell the coroner something, but it's not relevant to the investigation and the other parties definitely don't need to know. So we had a situation where we were representing a care home, we had lots of witnesses, lots of members of staff, but we weren't representing one member of staff because of a conflict of interest, and it was very, very personal. And this particular coroner really wanted to know why. Why aren't you representing them? What's the conflict? And we'd said, well, you know, it's really personal. And the coroner went, no, I want to know why. So we explained to the coroner what the situation was, but we said to the coroner, under the Worcestershire Principles and this particular data, it's not relevant to the inquest. The other parties don't need to know it. But if you really want to know why we're not dealing with this witness, this is why. And the coroner, under the Worcestershire Principles, said that's absolutely fine. So that's good to know. Not everything you send to a coroner is going to make its way into the disclosure bundle. But if there's something that you do think is useful for a coroner to know, you do need to assist them with their investigation. You probably should be sending it. And then it's up to the coroner to sieve it through. And if you need to make an application under these principles, again, that's something we can help you with as solicitors. So Halloween's coming up. I've got a few Halloween horror stories of data making inquests a little bit more difficult. So everything is obviously heavily redacted. These are some overnight notes for a resident in a care home. And I say there's actually nothing else on this sheet. To the right-hand side, there was the person's initials, which I've obviously cropped. But this is all that this sheet said. And again, the coroner looked at it, and on the face of it went, okay, great. This person's in their room whole night long, they're asleep. Actually, this person wasn't in their room. They weren't asleep. At about 10:30, they'd left their room. They'd left the entire care home and they died in another location. So these notes were really important because they hadn't realised this person had gone until later on in the morning. And the coroner said, well, hang on, these notes say that this person was in their room, but we factually know that they weren't. So why do the notes say that? So we worked with this witness, we did witness statements from them, basically explaining why they wrote what they wrote, because it's really important. The resident in question had been there for years. They'd never needed overnight checks. So it was very normal for something like this to be written. But we had to explain to the coroner, we'd written that Joan was in her room because we presumed Joan was in her room. We hadn't physically gone in and checked. And it took quite a bit of time. We had to write witness statements. We had to liaise with the witness a lot. And if there was, say, another column on this sheet saying, Joan is in her room, how do you know that I physically went in? Or how do you know that I presumed Joan doesn't normally have night checks? That would have been a lot more helpful and probably would have saved a lot of time. And those witness statements might not have been needed. Another example I've got, again, all redacted. These are snips from some MAR charts. So this, again, these are all inquests and things that have been disclosed during the course of inquests. This individual had passed away, and the focus of the inquest was very much so what medication were they on. So we zoomed in on all their different medications, what they were prescribed, what the titration was, what they were given, and when. And it was quite confusing. It was quite difficult. I've had to heavily redact it, but the MAR charts were quite difficult to read. And again, it took us quite a long time. Us as solicitors, we had a barrister involved. We worked with all the witnesses, and this person had passed away quite a few years ago as well. So remembering, oh yeah, I wrote that at the time, but what did I mean at the time? 2 years on, it's quite difficult to answer those. And again, we wrote witness statements explaining why the MAR charts were written in this way. But if they hadn't been written in this way, we probably wouldn't have had to do that. And luckily, the coroner was absolutely fine. They were fine with our explanation. They accepted it, and luckily our client was able to say, look, we know the MAR charts were quite confusing, but we've put in loads of work since on how to do a MAR chart better. But again, if the MAR chart had been perfect from the off, if that data had been a lot more legible and understandable, it could have saved us a lot of time. And talking of legible writing, I've got some handwriting examples. These are all real life handwriting examples. Again, we're dealing with a lot of handwritten notes. And I'm sure you guys can probably all read these if you're all in the healthcare sector. But these are things where I've come across and go, oh, hang on, what does that say? And I've had to read it more than once, or maybe ask a colleague, what does it mean? And it's okay as a one-off, but when a coroner's been sent 15 years worth of Jones records and it's all in totally illegible handwriting, the coroner's going to go, well, I'm not reading that. I don't have time to read that. And they're more likely to say, hang on, you can deal with this. You write me a witness statement and you come in and be our witness and you can talk about this in court. So it's really important that things can be read. I've got there, that's a blood pressure reading. And I remember us at Leicester Aldridge, we were all looking at this going, is it 179, 174? And again, a coroner doesn't have time to be questioning everything. We need to assist them. So it's just remembering things do need to be legible. It needs to be defensible. We need to assist the coroner. And similarly with signatures, a signature's legible. Is the signature clearly the person's initials or the person's name? I used to work in a private client team, and someone once signed something with a smiley face. That was their signature, was a smiley face. That's not helpful. That doesn't tell a coroner who their witness could be. It doesn't tell us who was around at the important times. And again, handwriting, particularly in situations of emergencies, the person's just passed away or they've just had a heart attack or something really awful, and you're just writing down what you can to remember it. That's great. At least it's written down. But could we go back and make it a bit more legible or type it up? Because it's all going to assist a coroner ultimately. And talking of assisting coroners, this is all publicly available online. This is just a snip of Dr. Karen Henderson. She's a coroner in Brighton, and this is just one day for this coroner. So if we actually look at it, she's got 6 inquests in one day. They're all documentary inquests, which mean there's actually no witnesses, so they're quite quick inquests. But Dr. Karen Henderson doesn't have much time to be reading lots of records. She's definitely got no time in between these inquests. And she's got a very small amount of time before all of these start and at the end of the day. And another thing to remember is a lot of coroners actually work part-time. These aren't most coroners' full-time jobs. So we do need to assist them. They don't have time to decipher things that are illegible or don't make sense. They can't be detectives. Our job is to assist them as much as we possibly can. Again, assisting coroners, I'm thinking about paper records versus digital records. This is an example where this individual passed away, and it was very important to know if they'd had their insulin and what their blood sugars were. That was very important in this inquest. And we had digital records, and the record said, yeah, this person was given their insulin, no problem. And we went, okay, fine, but we need to know what their blood sugars were beforehand. We don't have that bit of data. And staff had said to us, well, we absolutely would have taken it, or we never would have given the insulin. And the coroner really pressed for it. They said, well, we need to know what that reading was. And we said, well, where is it then? And they went, we definitely would have written it down. And then staff went, oh, hang on, I think I wrote it on a Post-it note. We went, okay, this is maybe a year ago. Have we still got the Post-it note? And to be absolutely fair to them, they found the Post-it note. This is the Post-it note with the blood sugar reading on it. And we were able to write a witness statement about it and explain it, and everything was explainable and fine in the end. But again, what if they hadn't kept that Post-it note, or what if we hadn't been able to find it? And that, one little thing scrolled down on a Post-it note was really crucial to this inquest. So it's understanding that actually anything can be data, whether it's a Post-it note, whether it's something written in a notebook, whether it was maybe written on a whiteboard and maybe a photo has been taken of the whiteboard. Anything can end up being disclosed in an inquest. This photograph was sent to the coroner, and it was really, really important. So again, key considerations, digital records versus paper records. We see both a lot of the time in inquests. Digital records, again, more legible to read, but it doesn't mean they're necessarily better for some slides I'll come on to in a minute. Again, particularly digital records, timestamps, is it accurate, or is this just the timestamp when we entered it online? Are they retrospective? And if they are, fine, but does it actually say that? Because coroners, they don't like that. We've had incidents where coroners have gone, well, hang on, this is time-stamped with that. And it's gone, well, yeah, well, that's when I went back in and edited it. But you haven't got the date when you originally wrote it. And there's no answer to that. And again, a coroner's not going to like that at all. And I've got here as well, it's impossible to predict which documents could be scrutinised. It could be your Post-it notes. Good practice across the board is absolutely key. It could be your training matrices, your supervisions, maybe staff disciplinaries might be relevant. It could be internal meetings, internal handovers. We've had it before where the suitability of a member of staff was questioned by the coroner. So we had to go back and look at their interview records and decisions making on actually hiring this person. Anything could end up being disclosed. Thinking as well about external professionals, when people are coming in to your care home to visit people, where is their data kept? Are they going away and writing their own notes and we're never seeing it? Do they write in your own professional visitors records? Or if you're writing it on their behalf, do they ever approve it? Is there any triangulation there at all? And I've got here as well, there's just lots of records to be thinking about. Do we know where these are? And again, would we be happy sending these to a coroner's court, which is a public court hearing? Your incident reports, your follow-up action plans, any meetings thereafter. What have we learned from Jones Full? We now know that she shouldn't be alone in a corridor. We now know she should have a Zimmer frame. Have there been any lessons learned, and have they been implemented, or have we just talked about them? Have we had to make any external notifications to safeguarding or CQC? Do we have copies of them, and do we know what happened next? Did they ever follow up? We see it quite a bit with police as well. Maybe the police get involved and then it's just radio silence, but radio silence doesn't mean it's been closed. Do we know what happened next? And as lawyers, we're always asking the so what. You made the notification, so what? What are they doing about it? Nothing. Great. But if they are, we need to know, and the coroner will definitely be interested. And I've got a point at the bottom here, don't redact unless it's obvious that it needs redacting. It is the coroner's investigation. Going back to what I said earlier, send everything to the coroner. It's then up to them what they want to do with it unless we make an application for them not to onwards disclose it. We had an example where there was a lady that had passed away in a care home, and there was an email chain between the hospital trust, the local authority, and the care home talking about this lady's care plan going forwards. And the body of the email was very, very relevant. But what the party had done was they had redacted everyone's emails in the top of the email. So, and they'd also redacted who sent it and everything. And the coroner went, oh, hang on, that's really important. We need to know who said this and who received it and who was aware of it and at what time. And it turned out that someone that had received this email received it while they were on annual leave, so they would never have seen it in between that email being sent and that person passing away. And the coroner went, I want the unredacted version. And anyone that's redacted a PDF knows once you redact it, you can't really undo it. So again, it delayed the inquest a bit. They had to go away, find this email from about 4 years ago, find the original chain and not redact it and redisclose it to the court. So, you know, unless it's really obvious, like other residents' information, maybe redacting is fine, but otherwise it's the coroner's investigation. Don't redact unless you are pretty certain you should be. And again, that's something we can help you with. Moving on to digital care planning and AI, building on what Isabel was saying, these are some real snips, again, from inquests we've dealt with where they've used digital care planning. Just where it hasn't been entirely accurate, and it's important for a coroner when you really want to rely on something, you're saying it's accurate. But if the rest of your care notes aren't accurate, then there's a chance a coroner go, then why should I rely on this piece? For example, if somebody's deceased and their body's been taken away by the police to the mortuary, it's not really a day trip because they're dead. Why is it being logged as a day trip? The series on the right hand side, offered supper, declined, offered a cup of tea, declined, awake, very happy, didn't want teeth brushed, declined. This person passed, they were actively dying and they passed away a few minutes later. Were they very happy? Again, it's all questions the coroner could be asking. Again, vape for 45 minutes. There was an emotional benefit, an intellectual benefit, a physical benefit, a social benefit, and a spiritual benefit. Again, it wasn't relevant to why this person died, but I think you'd have a strong case for saying vaping doesn't have most of those benefits. And therefore, is this really accurate as to how this person spent their day? Being aware of these little sayings for emotions, was content, was very happy. I've seen it where this person vomited, but they were content. What were they? Because it sounds like they just vomited. And again, a coroner would be interested to know why these things are being selected. A carer is actually thinking things through when they're entering these on digital care notes. Say these have all been cropped, but next to all of these on the right hand side, there was an actual human's name, the person that entered these. And that's really important. If something digital has been used or AI has been used, there still needs to be a human that did it, and we need to be able to trace it. And again, not quite AI, but it is using digital data to produce something that could go to a coroner's court. Do your staff use Google Translate at all, or anything to translate? And if they do we know when they do? And is it accurate? We don't want to disclose something to a coroner that's been translated, and then the person goes, well, I never said that, because then there's lots of issues with signing a statement, believing in how true it is. You need to know when third-party digital resources have been used to create these pieces of data. And again, focusing on data, thinking of some IT complications. This is another time when obviously this care home uses digital care planning. Again, this was produced to the coroner, and on the face of it, it looks like this poor person rang their care bell about 10 times in the space of 30 seconds. And arguably, that would be quite reasonable for the coroner to think this person was just pressing. Actually, that hadn't happened at all. This person had pressed it once, and the IT system had kind of made it relay and duplicate in the care notes. Luckily, we were working with this care home. They could explain that to us, and we wrote a statement about that to the coroner, explaining that, you know, please don't think this person was ringing 20 times and we were ignoring them. It's actually totally inaccurate. But you've also got to think, again, Joan, been here for 15 years. If we're trawling through all of Joan's digital care notes, would we notice this from about a year ago? What if it's really important? Are we aware of when digital care planning has gone wrong and where there's been IT errors? And if so, can we actually explain what's gone wrong? Would you know? Do you have an IT team to talk to? Luckily, in this situation, we could. But if a coroner had turned around and gone, they rang their care bell 10 times, and there's no proof of anyone coming to attend to them, that wouldn't have been unreasonable for the coroner to think based off of this record alone. So there's a few practical considerations as well. The care records are really important. Care notes, incident reports, they should be objective and they should be accurate. I've seen a few care records talking about maybe a resident's behaviour, maybe challenging behaviour, and there's been comments that maybe are quite opinionated about the person. This person certainly picks the time to do X, Y, Z. That's not appropriate. And if we're going to have to send that to a coroner, or if again CQC get aware of the inquest, does that look caring? People need to be aware that anything they ever write in a context of an individual that they're taking care of, it could end up going to a coroner. And once it's disclosed, once it's in that disclosure bundle, it is publicly available data. And people don't, but anyone can attend an inquest. Anyone off the street can request, can I sit in on that? And the coroner's probably going to go, yeah, of course, it's a public court hearing. So we need to be aware of what we're writing and making sure it's very objective. Paper records, back to Halloween horror stories. Don't give your original paper records away without having copies. I'm dealing with an inquest at the moment where a lady died, I think, a year and a half ago. Police are involved with the death. They took all the original care records and they've never given them back. The coroner's now calling an inquest and saying, I want this witness, this witness, I want everyone to write statements. And all the poor staff are going, we don't remember. It happened a year and a half ago. How can I do an overview of all of her care needs and what her medication was and X, Y, Z when I don't have the records? And we've done what we can based purely off of these people's incredible memory, to be honest. But an inquest rarely happens immediately. So you do need to know, in a year's time, could I talk about this? And if I couldn't, where can I find the data that could help me? And again, how long does your company keep data for? And where as well? Are they put in an archives facility that's at the other end of the country and it's going to take a week to physically get them? Can we find them online? A coroner should do an inquest fairly promptly, but we do see them doing them several years down the line. So it's really important to know how would you access anything if you needed to. And again, keeping a note of quorum. Who was present at meetings and handovers? Let's say that there was a handover before Joan's fall, saying, guys, we need to keep an eye on Joan. She's been having a lot of falls recently. Who was present at that meeting? And do you actually keep a note of that as well? What if the one member of staff that was there when Joan fell didn't actually go to that meeting and they didn't know she'd been having increased falls? The coroner might really want to know that. Do you record it? Where do you record it? And where do you keep it? And again, it's impossible to predict which members of staff might be scrutinised by the coroners. It's potluck, really, if you're the poor member of staff that finds the person passed away in bed, or that's fallen over in the corridor, or they've fallen over outside the care home and they're found in the car park. You don't know who could be the focus of a coroner's investigation. So, you do need to make sure you're quite confident from all angles that you could produce the data that you might need to produce. And again, more strategies for record keeping and presenting your data to the coroner. In terms of triangulating data, a coroner will pick up if the daily notes and the incident report and the staff witness statements all say a totally different thing. Do we actually know what happened? And are we saying the same thing across the board? What if there's photographs and there's CCTV that might say something different? How are we checking that everything's properly triangulated? And again, what I said earlier, archives, what do you keep? Where do you keep it? And how long? If you needed it, if a coroner comes to you and goes, I need a witness statement within the month, but it's going to take 6 months to get your archives from Scotland, what are we going to do about it? And again, that's where we can help you. We can talk to the court on your behalf and we can explain the practical difficulties. My next point, policies and procedures. What was actually in place at the time this person passed away? So again, let's say Joan passed away 2 years ago. We might have a beautiful new falls policy now, but actually what was in place at the time when Joan passed away? Because that's what the coroner will be focusing on. What were staff following at the time? Were they following the right policy at the time? And do you know where you can find old policies, old procedures? And again, how long are they kept for? And again, final point, decisions. If a decision's made, we're not going to give Joan a Zimmer frame because she absolutely hates it and refuses to use it whenever it's given to her. If it's a risk, if we've assessed the risk and we've come to a decision, is that decision documented? Do we say by who? Who else was involved? Who else was consulted? Who was it communicated to? Were any third parties involved? And again, where do we keep that data? Because a coroner might really want to know why we hadn't given Joan a Zimmer frame. So it's really covering yourself from a lot of bases. A coroner could, think of any of these things to ask you. In terms of how you can use other people's data to help you, going back to what I said earlier about prevention of future deaths reports, this shows how boring and sad I am, but they're all publicly available online. If everyone wants to have a read of them, you can just type in PFD reports and you can find all of them. You can use that data to your advantage. If you know what coroner's court you're going to be heard in, so we're based down in Bournemouth. If I know I'm going to be heard in Bournemouth Coroner's Court, and I know who the coroner's going to be, and I know that Joan died because she fell and hit her head, I could search for falls-related deaths in a care home. There on the top right, we can see there were 47 reports made about falls in care homes and coroners being worried about the way a fall's been dealt with in a care home. And we can read those reports, go, oh, hang on, this coroner only last week said that they were really, really hot on falls risk assessments, whatever. Use it to your advantage. Know what coroners are hot on. We can see their records. I've just done some random searches. Record keeping, 49 results. Communication, and I did read these, communication between like third parties and families, 21 results. Staffing issues, 74 reports. And these are just reports that have been made recently. So that might have been whether there was the right staff on shift, the right qualified staff, the right number of staff. Use this data to your advantage. Hopefully you'll never ever have a PFD report made and aimed at you, but we can take advantage of the ones that have been made to understand more what coroners could be focusing in on and what their concerns could be. And if you know the coroner you could be in front of, then even better. So some questions to take away and think about. I'm not here to scare you, but again, it's good to think, are your records reliable evidence in court? Particularly, coroners like to get statements from care home managers. If you had to attend court as the care home manager, give an overview of Joan and all of her needs and the incident where she died and what we've learned since, are you happy for the records you could be producing? Again, you're going to have to stand up to some scrutiny as well. It's not an adversarial process, but it is an investigation into what happened and maybe what went wrong. So the coroner is going to be reviewing things. The other interested parties, interested persons as well. So the family will see everything. If there's other parties involved, there might be solicitors, there might be barristers. They're going to be read by a lot of people. But are you happy with what you could be disclosing to the court? Is there anything off the top of your head that you wouldn't know where to find if a coroner asked you for it, or you wouldn't know who to ask? Could we plan ahead, go, hang on, where do we keep all of our old policies? Who do I even ask? Where is our archiving facility? If you're maybe a small provider, you know exactly where it is. But if you're a larger provider, hang on, if I wanted to find something from 2 years ago, where on earth do I even begin? And is there anything you could make a little bit stronger or more accurate? Is your documentation and data defensible if you had to attend an inquest? Hopefully you never will, but that's why we're here. We're here to help you. And I was going to open up the floor now to some questions, if anybody has any, or if Fiona's picked up on any in the Q&A.
Hello, Fiona's swapped with Eleanor from Digital Care Hub. Yeah, thank you, ladies. I missed the first half, but it was really informative. We've had a few people saying that they're really interested and they wanted the slides and things afterwards on the Q&A, which is great. But if you've got any more specific questions, please do pop them in the Q&A. We've got just something from Sharon on the chat about this is where DSBT and retention schedule comes into its own, helping providers pull together this type of data and information on your record of processing activities. Don't know if you've got any take on that at all, from your point of view.
Yeah, we absolutely agree with that. I would again kind of highlight what both Isabel and Maddie touched on in terms of just always kind of second guessing yourself in terms of the type of information that you're putting down, the type of commentary you're putting down. The second phrase, the first phrase, I appreciate you weren't here for this, and then that I was told to kind of get tattooed somewhere on my body when I work at the Royal College of Nursing, was about if you didn't record it, it didn't happen. The second one was never put anything in any note that you wouldn't want up on the notice board. And
Yeah.
you
That's-
just, especially when we're talking about inquests, they are supposed to be, as Maddie pointed out, you know, it's not supposed to be a situation of argument. It's not criminal or civil liability. There is an excellent way to get the family, your enemy, from the word go. If they've read something and you said, oh, well, yes, but Joan was a bit doddery that day. She'd never listen to us anyway. No, it's not helpful. There are different
Yeah.
ways to write that, and there are different ways to apply that to risk assessments and things going forward. So yeah, just thinking about what your data would look like from an objective point of view.
I think, I mean, I had a thought about, I enjoyed the scaring the handwritten note, Maddie, that you were saying about your Halloween scare stories. And it's kind of good, I think, about how things are recorded, especially with the digital way now, when you said about sort of that man who was basically was dying and they'd put, oh yeah, he refused dinner. He seemed happy. He refused a cup of tea, but he seemed happy. You're like, and then when you told us that, I was like, why would someone put that? But maybe they were just in the moment, like that was their only option. Like it's really interesting, I think, for care providers to think about, can they personalize the responses better and can they add those as options? And I think something that came up for me was you talked as well about the handwriting. Like, is that still a major concern now, much more is digital, or
Um,
it's still things
I
like
would say it's still quite common for us to
okay.
talk to each other and say, "What on earth does this say?" It
Yeah.
does happen. I mean, we deal with a lot
Okay.
of inquests. It does happen. Normally, we can decipher it, but the whole idea is if you've got a coroner and you've given them, say, 100 pages of handwritten notes, the coroner doesn't have the time to do the same thing that we can do as solicitors. And again, it's a pretty bad way to get a coroner not on your side by giving them stuff they can't read. A coroner doesn't. We saw that timetable of that assistant coroner in Brighton. They don't have the time to be
Yeah.
deciphering this. And yeah, the more important the record is, if it's how they died or an incident or written down in haste, I'd argue the more legible it should be. Everything should be legible, but the more important it's going to be, we need to know what it says. We've had situations where we've had staff have written their own witness statements and they've sent them to us. We've gone, I can't read that. I can't. We can't send it to a coroner because it's not
Yeah.
legible. So when we've spent time, reading it ourselves, typing it out ourselves, making it nice for a coroner to read. So again, we can help with that. And if you're not on digital records, that's fine. We're not saying paper records are worse, but they do have the risk of legibility. But
Yeah.
no, we do definitely still see it. Definitely.
And I
Okay.
would
Yeah.
say, oh, sorry, Anna.
Yeah. Go on, Nicola.
No, I was just going to say that there is also that danger period that I think we've all encountered when you have that transition point if you're moving from paper records to a digital care system, and you have some people that are going through the training and some people aren't, and everybody's working in the background to try to get those care records on, and then you have poor Maddie in the background or Isabel or I trying to figure out, okay, well, this staff member was still on the paper records and this staff member was on these records. And how are we demonstrating that different people were being able to have sight of all of the necessary information for handovers and things?
Yeah. So we're in a bit of a hybrid world at the moment. Yeah. So not going on.
One thing we haven't mentioned that we also come across quite frequently is acronyms. There isn't a standard set of acronyms that's used universally in health and social care, and yet people think that somehow by osmosis we're meant to understand what they meant by, for example, LH. That can create issues in terms of communication. So if you are going to use acronyms in your service, have a list of acronyms that are agreed and everyone signs up to using the same ones. Because it's very, very helpful if you have that, because trying to remember what you meant by those initials a year down the line can be very tricky. And we've seen entire sentences that are written in acronym.
Yeah, that's so health and social care sector, isn't it? Yeah, we even had this conversation at Digital Care Hub. I was like, all these acronyms we need in one place, and we started it, and then the acronym list just grows. So yeah, definitely. So I guess like picking up on your like all of that, the acronym, the handwriting is kind of maybe having it as part of training as well, like embedding it from the beginning with your like team, so it just becomes a default that yeah, they know that this could be used later on, so it needs to be legible. legible writing and clear like information they put on their records as well. But and I just had another and apologies if this was picked up in CQC section, but is it something that CQC are going out now and looking for like digital records, or are they kind of is it a bonus, or do they not really, they're just happy with anything? Kind of, does it do it in your favor? Does that make sense?
So CQC haven't directed that they require digital care records.
Yeah.
We have seen some reports where they have positively picked up on the use of digital care records, usually from the perspective of the use of them for analytics to prevent an incident happening again. Equally, that could have been done with a MAR or a sensor mat, and appropriate analytics are the same. In terms of what CQC look for, they're looking for a record of the care that was provided, that is accurate, that is complete, hopefully lacks opinion, and was recorded at the time. We often don't see that, be that if that's electronic or handwritten. And you just need to, the provider needs to take a step back, give themselves the time to say, okay, this is our system as a whole system approach. How are we recording? Does it match what our policy says we're doing? And if it doesn't, is that because it's changed? Because CQC will triangulate that when they come in, and CQC come in already having some data. So they're going to consider what they already think they know about you and your service. For example, if they're coming to your setting off the back of a whistleblow, and they're going to look at whatever that information is that they were informed about. When they come to triangulate, are you setting yourself up for an issue because you haven't given yourself the time to think about this in advance? Or are you actually going to be able to put your best foot forward and say, okay, we recognize we had a problem. This is what we found. This is what we did about it. And, this document, physical document, signposts to this part of the electronic record, which in turn signposts to our policy, which we did review on this date. And we did record that we reviewed it. And actually, we kept the previous version as well.
Yeah, I thought that was the kind of the way. But interesting that it is like the triangle approach, and the policy matches what you're doing. But yeah, we'll see what happens with them, I guess, as we move forward. Well, thank you very much. Oh, we've got one more question. Hang on, it's just popped in. How well drilled are CQC on data security, etc.? Are some inspectors more in tune in the requirements on this topic than others?
Absolutely. Yes, it is definitely the case that some inspectors are certainly more in tune than others. And actually that goes to a point that leads on from the point Isabel was just making in terms of your systems. You can have the best system in the world and you can have your staff completely trained. But if CQC inspectors come in and they won't engage with those systems, whether that be about sending data securely, which was obviously an example that Isabel had said earlier, or whether it's about physically not using your systems, I would always say during that point in time, post-inspection and potentially pre-feedback, or even at the point of feedback but prior to the draft inspection report, really making sure that you can send an easy guide to CQC to say, this is what our systems look like. This is what the person who's the staff member who's got the tablet in front of them looks at. Because the number of times that we have criticisms on CQC inspection reports that says, well, the daily notes didn't reference the fact that the TVN came in today, and therefore staff didn't know what the photograph looked like of the sacral wound. Well, if we have, I mean, it sounds like a very specific example because it was an example. We literally took a screenshot, it's not a screenshot, like a photograph of what was up in the tablet. And the tablet had a tab that said daily notes, had a tab that said professional visitors, had a tab that had photographs. So the person that's holding the tablet has all of the necessary information in front of them. But if the inspector's not willing to engage with your systems, then they don't understand and they wouldn't appreciate that. Again, that's part of the factual accuracy challenge process, but it's also about making sure your staff have the confidence to be able to say, we do have the appropriate systems, we do have the appropriate data security. And that we have the language to be able to explain that to you and to challenge you as inspectors.
Which is, yeah, which is what you put on earlier, wasn't it? It's about challenging them to say you've actually got the information. Brilliant. Thank you very much. No more questions have come in. If anyone has further questions, do contact us, Digital Care Hub, if not through Leicester Aldridge. We will be sharing the slides and also the recording will go up on YouTube for you to have a look at for those registered. But thank you everyone for joining us, and thank you, Maddie, Isabel, and Nicole for hosting. Had really interesting feedback. So I'm sure there'll be quite a few people watching it back. So thank you. Thanks, everybody. Bye.